In this video, we're going to talk about so-called reverse confusion. And so what is reverse confusion? Forward confusion is when somebody thinks the defendant's product is that of the plaintiff's. So somebody markets a soda under the name Coke, K-O-K-E. That's going to draw consumers who think they're getting a C-O-K-E Coke. Now, reverse confusion is when consumers think that the senior user's product is the junior user's. That is, the plaintiff's product is actually the defendant's. So imagine you have a small soda maker named Eagle, and it makes sales in sort of scattered regions, but isn't particularly successful, but it has trademark rights. And then Coca-Cola comes along and releases a sub-brand of its own under the Eagle mark, and they mount, a huge national advertising campaign. What's going to happen is that consumers may think that the senior user makes the Coke product, or worse, is actually knocking off the Coca-Cola product. So we have a recent example of this kind of claim where the Cleveland baseball team announces plans to rename themselves the Cleveland Guardians. But it turns out that in Cleveland, there's already a roller derby team with that name, and that led to that senior user filing suit, making a claim of reverse confusion. So what is the harm of reverse confusion? We don't have diverted sales from the senior user. The senior user may even gain some, as consumers may be moved by the intense advertising of the junior user and think that the senior user is actually the junior user. But when this happens, there is a loss of control over one's goodwill and reputation. So before, the primary meaning of Cleveland Guardians was that of the roller derby team. And now when the baseball team comes in and markets the way Major League Baseball teams do, the primary meaning of Cleveland Guardians and the connotations thereof will be dictated by the baseball team. And for the senior user, they may be seen as making a knockoff product. So they may lose sales from consumers who kind of want to punish them for what they think is the copying of the junior user, when in fact they are not copying the junior user's mark. And this knockoff issue is actually alleged in the lawsuit that the roller derby team filed against the baseball team, saying that they have experienced logistical problems with merchandise suppliers, some of whom initially refused to fulfill orders for Cleveland Guardians merchandise because they think the Indians, the former name of the team, hold exclusive rights to the name and thus consider Cleveland Guardians official merchandise as akin to counterfeit goods. They also allege that defendants' unauthorized use of Cleveland Guardians in connection with the sale or provision of merchandise and services will destroy the goodwill the plaintiff had established in its distinctive name, causing consumers and potential consumers to view them with disdain as a supposed infringer. And also you could have the possibility of people, usurping good marks. Somebody has a good mark, someone say, hey, nice mark you got there. Be a shame if someone were to appropriate it with a larger ad campaign, and indeed that's what could happen. And so that is the potential benefit of allowing a cause of action for so-called reverse confusion. But this kind of cause of action has costs as well. For one thing, it's a burden on larger sellers when senior users with weak marks are able to spring lawsuits on innocent junior users who have invested in broad marketing. Now, in the Cleveland Guardians suit, the claim was that the baseball team could easily have known of the trademark of the roller derby team, and indeed that's what they allege. But we do have this potential for the possibility that a senior user that is a small operator does not develop a strong reputation, does not have a lot of goodwill, may see entry by a well-capitalized junior user as potentially providing a business opportunity and something akin to what is said to be patent trolling in the patent law context. And indeed, in the Guardian suit, the roller derby team cited a very low settlement offer on the part of the baseball team. And it's arguable that in some reverse confusion situations, the harm to the senior user may be overstated. So in the Guardian's case, the plaintiff says coexistence is simply impossible. But what happens at the end of the day is that there is a settlement, and at least as of the moment that I'm recording this video, both teams are still using the name, suggesting that the situation is not so untenable after all. But I think an especially interesting consequence of the reverse confusion cause of action is the interaction with weak trademarks. And so in a situation like the Cleveland Guardians, that seems to be a fairly strong mark, and there's no real reason why the baseball team needs to have that mark. It just turns out that they selected a mark where there was already a senior user, and then we could argue about whether the roller derby and baseball markets are too close together or not. We don't get to that in the lawsuit because the parties settle. But what happens when the mark in question is weaker? Does that exacerbate the problem of potential holdup by the senior user of a wealthier junior user? And that takes us to a really interesting recent case called Ironhawk Technologies versus Dropbox. And so the plaintiff is a company named Ironhawk, and it sells data transfer software that transfers data efficiently in bandwidth-challenged environments. And they market their product under the name Smart Sync, and they have a registration for that term. The defendant is Dropbox, cloud services provider, and they have Smart Sync not as a discrete product, but they use the term to describe a feature of the Dropbox product that allows cloud account holders to conserve hard drive space by smartly syncing what's on their hard drive with what they have in the cloud. So it's part of a larger product that is branded as Dropbox, not as SmartSync, and not a standalone SmartSync product. So what's going on? What kind of a mark do we have here? Why isn't Ironhawk using Ironhawk as a brand name? Now, Ironhawk is strong. And this would be a very, very easy case if Dropbox came in and tried to market their services under that name. But of course, they have no reason for doing such a thing. And so is SmartSync even distinctive in the first place? And, your mileage may vary, but I think the term SmartSync gives you a fairly good idea of what the product is designed to do. And certainly when you combine it in context with the advertising, certainly in the Dropbox case, it certainly seems to be a descriptive kind of use. But even if the mark is going to be deemed by a court as being suggestive, not actually describing but merely suggesting a quality and therefore being entitled to be treated as inherently distinctive, is this the kind of mark that we think deserves strong protection in the marketplace? Or maybe we think that it's the kind of mark other sellers in the marketplace may want to use. And indeed, if you go on Google, you'll find that there's other third-party uses of the term SmartSync that are out there. And so I think there's a good case to be made that this does not really evoke a particular brand or seller so much as it does a product category. And so what should Ironhawk's use of a weak mark do to their litigation prospects? Well, hold that thought for a minute, because let's shift over to Dropbox. Why is Dropbox using the term SmartSync? And again, they're not branding a particular product. They're using it as part of the operation of their branded Dropbox service. The powerful mark here is Dropbox, not SmartSync. And so I think this is arguably akin to a descriptive fair use. Now, is confusion even plausible here? And here's where we get to something that's really interesting about this case, and that is the consequences of styling the claim as a reverse rather than a forward confusion case. Because nobody thinks for a second, and Ironhawk is not alleging here, that people are going to be making purchases of Dropbox's product thinking that they're getting Ironhawk service. And so the district court looks at all this and gives Dropbox summary judgment, saying, no, there is no plausible claim of likelihood of confusion here. And the Ninth Circuit reverses in an opinion by Judge Smith and concludes that even though we're not saying that Ironhawk is going to win this, this is a case that ought to reach the jury. So why is that? The majority goes ahead and applies the Ninth Circuit's version of their multi-factor test. And so let's look at the individual factors. So one of the factors, of course, is strength. And here we have this tricky problem because, again, SmartSync is, even if we want to make the case that it's inherently distinctive as being suggestive, it is not a strong mark. However, the majority says, well, it's possible that it's suggestive, and that's a fact question, and that is something that a jury could conceivably find. But again, is it actually strong? And I don't think there's a very strong case that it actually is. But here's something really interesting. The majority says the key is actually the strength of the Dropbox mark, the better to swamp the reputation of Ironhawk SmartSync with a much larger advertising campaign. And so here's where I think there's something really tricky about reverse confusion, and that's what it does to trademark quality incentives. Is Ironhawk getting rewarded for selecting a weak mark, and is Dropbox getting punished for creating a strong one? And if that's what's going on, it's worth asking, is this good for the consumer information ecosystem as a whole? Do we want sellers to be selecting weak marks? Do we want to punish defendants for using and relying on strong ones? And the same tension comes up in the court's consideration of the similarity factor of the multi-factor test. Because Dropbox is saying, look, we're not marketing this as SmartSync, we're marketing it as a SmartSync feature of the Dropbox product. And Dropbox is, of course, a very strong mark, and it's a mark that is not at all remotely similar to either SmartSync or to Ironhawk. And here's the majority does something, rather perverse. It says, in a reverse confusion case, the junior user's use of a housemark can also aggravate confusion by reinforcing the association between the mark and the junior user. And so, okay, I mean, you can buy that logic if you will. I mean, I think it's a stretch, but it raises the question: what if Dropbox hadn't used its housemark? What if Dropbox had just marketed its product as SmartSync? You can bet that that would have weighed very strongly in favor of a likelihood of confusion in litigation brought by Ironhawk. Because of the reverse confusion styling of the claim, it sort of heads Ironhawk wins, tails Dropbox loses. But under this factor, Dropbox is kind of stuck by virtue of the fact that the cause of action is reverse confusion, one in which the case for consumer harm is not nearly as strong as the one that exists in a forward confusion case. Then we get to other factors of the case where, I'm not sure it's worth going into great detail here, but there is sort of disputed evidence about actual confusion. The majority sort of says, look, the evidence that's there is not very strong. We actually have some doubt that a jury is going to find this factor to be in Ironhawk's favor, but, you never know. And so there's this sort of deference to letting things get to actual adjudication rather than resolution on summary judgment. And of course, the issue with that is it strongly increases the potential interorum effect of the cause of action being raised in the first place, raising the incentive of the defendants of the world, the Dropboxes of the world, to offer some kind of settlement. Sophistication: Ironhawk's primary customer was the U.S. Navy, and the court acknowledges that the Navy is a sophisticated purchaser. However, we have, again, these highly disputed allegations of actual confusion, and the majority, interestingly, does not really kind of get into the issue of, well, what kind of confusion is this? Like, what is the depth? Is it confusion that is actually likely to affect a purchasing decision? Intent: Dropbox knew of the mark before launching their product, and so a jury could find culpable disregard of the risk of reverse confusion. And again, it raises the question, what risk precisely? The risk that they might be sued by Ironhawk? That's not bad faith. That's not intent to confuse, or actual harm to Ironhawk. And so what if Dropbox had a good faith belief that there is no actual plausible confusion here? Why does knowledge of Ironhawk's mark equal culpability? And of course, it's an issue we've seen elsewhere in the application of the intent factor, in keeping with its dubious relevance to whether or not there's an actual likelihood of confusion or not. And it's worth noting that the majority does not say that there's actual likely confusion. There's even some skepticism working its way into the opinion, but it's unwilling to cut off the case at this stage. And, trademark cases are generally fact questions, and that's how courts generally describe them, but it's worth noting the normative consequences of allowing a claim like Ironhawk's to proceed, insofar as it raises the incentive of parties to file weak suits and for defendants to settle them rather than rolling the dice with actual litigation. And that takes us to the dissent by Judge Tashima, who notes that, okay, the majority is using the right principles here. We're, using the multi-factor test as we should, but this is a really incorrect application. And so when we're thinking about the multi-factor test, we shouldn't be thinking about it as what he calls a rote checklist, but that's how the majority is effectively applying it here. And so it's an interesting question whether or not the multi-factor test is having a substantive consequence on this case. That maybe if a court were just sort of ask, is likelihood of confusion plausible here? A court might just kind of look at everything and say, all things considered, yes, all things considered, no, but maybe going through the factors, marching through them, boosts the claim of Ironhawk in a way that is detrimental to Dropbox's chances. In any case, Judge Tashima says what we need to do is apply the multi-factor test flexibly based on total circumstances, and looking at the totality of things here, confusion is simply implausible in light of the sophistication of the buyers. All of these factors, the sophistication of potential commercial customers, the expense of the product, and the manner in which Ironhawk markets its product, wholly eliminate any realistic possibility of consumer confusion in this case. But he's in the dissent. And in the aftermath of this case, what do we have? We have a settlement. And the parties settled the suit for undisclosed terms. And at the moment that I'm recording this video, both companies continue to use the term SmartSync. That raises this question about what does that say about the merits of the cause of action. And the final thing I want to observe about this case is that it's another one of those cases where the framing of the cause of action, in this case reverse versus forward confusion, allows the court to overlook context that in a normal, traditional point-of-sale forward confusion case, a lot of context that would mitigate any real plausibility of a likelihood of confusion finding. And so once again, we have a situation where the cause of action is arguably less tied to consumer welfare than the traditional trademark cause of action, but yet is easier for the plaintiff to prove. And there's something very odd about that, but that's the way the case law shakes out, and that's one of the potential issues with the reverse confusion spin on the likelihood of confusion cause of action, and that's what makes the Ironhawk case a particularly interesting recent case.